Hello, Kip, Veronica, and Malik. Today I'm going to be talking about costs associated with filing a workers' comp claim to court via a 512 appeal. So it's 4123.512. And so this is what happens when your claim is at the administrative level. Either the entire claim has been denied administratively, or you have an allowed claim and you're seeking to have additional conditions added to your claim, and one or some of those additional conditions have been denied, and you've filed a notice of appeal and a complaint within 60 days after receipt of your refusal order relative to the denial of that claim or condition. And I think the misconception with a lot of folks is with contingency fee, that also includes that you get these workers' comp trials; those are also free. And the reality is, these things they do cost money. So I'm going to talk about what those expenses are, and with again 512 appeals and this would be you have your administrative hearings at the Industrial Commission, and then a 512 appeal is at the court of common pleas, generally in the court where the work injury occurred. So when you file a 512 case to court, there's three possible outcomes of how that thing's going to proceed. So you'll either have your full jury trial, with or without a jury. So you'll either have a trial with or without a jury. You may settle your case and not go to trial, or you may dismiss your case either with prejudice or without prejudice. So if it's your first filing, you dismiss without prejudice, and then Ohio has what's called a saving statute, and you can refile your dismissed case within a year of the dismissal of the case. Sometimes with these workers' comp claims, and sometimes these things are what are called file to settle. So you're filing a condition or a claim with the purpose of negotiating a settlement with either the employer and the attorney general representing the BWC, or the attorney general if the employer is no longer involved. But if you don't settle and you don't dismiss the case, then you have to determine how much you're going to push the case, and how much how far you're going to push it. And depending on how far you push it is going to that's going to incur additional costs. So first, starting out, let's look at the actual filing fee. And I'm going to look at the Franklin County Court of Common Pleas, but they have what's called Local Rule 9 in the local rules, and it gives out the costs to file. And in Franklin County, the cost to file a workers' comp case, a 512 case, is $225. So that's $225, not crazy expensive. And most of the time, you could either have a bench trial, which would be a trial just before the judge. So in that situation, it really wouldn't be that different from an administrative hearing, except there'd be the rules of evidence, etc. And you wouldn't have a jury with a bench trial. It's just the judge serving as the finder of fact and the finder or the determiner of law. Versus if you have a jury trial, the judge is going to interpret law and the jury is going to interpret fact. And generally, with these, for the claimants, the plaintiffs, you generally want the jury determining fact. And again, and if you just have a bench trial, it's going to be more or less kind of like how it was at the Industrial Commission or the administrative hearing, where you had one person, the hearing officer, determining fact and issues of law. So that's the first thing. And to get a jury, again, it's not free. It's about at least in Franklin County, it's about $300 for a jury deposit. So it's $225 filing fee, jury deposit $300. So now every workers' comp case, unless it involves what's called a common knowledge injury, is going to require a medical expert to opine. You're going to need a medical expert to opine that, one, the condition exists, and that the condition was a approximate result of the work injury. in some capacity. Common knowledge injuries would be an injury like a laceration, a bruise, those sorts of things. And the case law or the theory behind it is you don't need, everybody knows what a cut is, everybody knows what a bruise is. They could see a bruise. It doesn't require an expert to explain, you got a bruise or you got a cut. So generally you don't need an expert in those cases. But in all other cases, sprains, discs, rotator cuff tears, anything like that, you're going to need a medical expert. And so that's where you're going to run into, these are the bigger expenses, is the medical expert. And you're going to have two issues there. So the first issue is, will your BWC physician of record, or will the treating the surgeon who may have done surgery on the body part, if this is an additional condition claim or it's a totally denied claim, are you going to ask that person who actually examined you previously, or in combination with the workers' comp claim, are you going to ask that person to be the expert? Will they be the expert? If they're not going to be the expert, if you don't have your BWC doctor or surgeon or primary care physician, whoever examined you in relation to the condition that you're requesting via the workers' comp trial case, if they're not going to be your expert, then the next issue is an expense you're going to have to dive into is getting an independent medical evaluation. So what's going to happen there is you have to find a medical expert who will agree to do an independent medical evaluation, and then you're going to have to pay that person to do the IME, and typically they want to be paid before they do the IME and or review records. The caveat there is these folks, the key word is independent. So they might do an independent medical evaluation, and that independent medical evaluator might actually determine that, one, you either don't have the condition or you do have the condition, but it's not a proximate result of the work injury. And that is a possibility, but you'll still have to have paid that independent medical evaluation for their IME that they've conducted. And these things, they can range anywhere from, it could be, if it's a soft tissue thing like a sprain strain and it's pretty, like one body part, that might not be so expensive, maybe $200 to $500 to do the IME. If it's, like these orthopedic doctors with the shoulder issues, knee issues, or like a back, like a neurological thing or a disc, those folks, you'll typically have to pay them between anywhere from $1,500 to $3,000 to do an IME and file review, and depending on how many records, that cost may go up or down. But that's for them to do the IME. And then the other thing to consider is, the more specialized the condition, the more unique the condition that you're asking this to get evaluated, those folks are going to cost more. So if you have like a brain injury, and you need a brain injury expert, if you're actually asking a brain injury expert, those folks are going to be considerably more expensive than, say, somebody evaluating soft tissue, or you need, for whatever reason your claim's denied because your employer's claiming that you're under the influence of drugs or alcohol. You're going to need to get a toxicologist to evaluate all the records and minutiae, and those folks, again, it's probably going to be expensive. So nevertheless, and again, they might not actually support either the condition or that the condition is a result of a work injury. So but you still have to go get that person. Okay, so you've got your IME, and good for you. The IME supports the condition, and they feel that it's a result of the work injury. Great, you're not finished. So the reason why you're having the medical expert for the court case is, what you're going to end up doing is, you could have your medical expert show up live to court and testify live before the jury, but the more typical thing to happen is, what ends up happening is you depose your medical expert, and it's recorded by a videographer, and then there's a transcriptionist, court reporter transcribing what is stated during that deposition. So you'll do your direct, the employer's attorney, either the employer's attorney and the BWC's attorney, the attorney general, or both. They'll do cross-examination. So you have to pay that medical expert's time. I've seen anywhere from $700 up to $2,000 or more. They'll charge that for an hour, and then every 15 minutes over that hour they might charge, depending on how much their base fee is, it might be anywhere from $200 to $300 or more for every 15 minutes you go over an hour. And then a lot of times those folks, again, they'll want to be paid some kind of deposit up front, and then if you don't use all the money, they'll reimburse you for whatever money you don't use. So you got to pay those guys, and then you're going to have to pay the videographer for his or her time, and then you're going to have to pay for the court reporter for his or her presence and services, taking, transcribing everything. So if you're going to get, you're going to need to file the transcript to court. If the deposition goes for an hour and a half, that might be anywhere from $400 to $500 maybe for that court transcript from the court reporter. So you have to pay that, and then if you need the videographer to edit the video, to remove objections and whatnot, that might be, you might end up paying $300 or $200, $300 for that. So that's for your medical expert. Okay. So your employer may depose you, and obviously they're going to pay for that. But if your attorney needs a copy of the transcript, they might have to pay for the transcript of your deposition. They might want to get the copy of the transcript because there might be things that they need to prepare for in trial, or write motion limines and these things. Motion limine is something you write to prevent information coming into trial. If you have any folks that you want to depose, you might depose folks, and then obviously you want those transcripts. You might also want a videographer, you might want to videotape them as well, so there's going to be expenses with that. If you need to get certified medical records, so if your attorney and the employer and the BWC, if they stipulate to the authenticity of the medical records, great. You don't really need certified medical records. But if they're not going to agree to the authenticity of the medical records, you're going to need to get certified medical records, and/or you're going to need to get the records custodian to appear live at trial, which is super cumbersome and super expensive. You're not going to want to do that. So you want to get certified medical records, depending on how many medical records you're going to need to get. That could be, that could add up. It could be anywhere from $70 to $200 or more. And then there may be other ancillary expenses that you need to throw in there. So these things, these are all expenses that are associated with the court case. And one thing you have to remember with these workers' comp cases is, again, what we're pursuing via the workers' comp trial. It's not a personal injury trial where you're going to ask the jury to pay you some monetary damages for pain and suffering and your economic and non-economic loss. The remedy for a 512 case is the right to participate for the conditions that you're pursuing through either the denied claim or there are other additional conditions which were denied. So all you're asking for is the right to participate for those conditions. And what that means is the right to participate, it basically says you have the right to participate for these conditions. All that says is you can go back to, at the administrative level, the BWC, the Industrial Commission, and you may get compensation, the various form of compensation you're entitled to for those conditions, and you may receive payment of medical treatment for those newly allowed conditions if you prevail and you have the right to participate. But that's a may, it's not a shall, so that you might not. So you might get the right to participate for, a herniated disc in the neck, for instance, and you request it's allowed, you have the right to participate for it, and your doctor wants to do a fusion of the neck, it goes through the ADR process and it's denied. That's a possibility. So all you're getting with a workers' comp case is at court is the right to participate. You're not gonna, again, the jury's not gonna say, oh, we're gonna pay $1 million. The jury's not gonna give you anything. They're gonna say yes or no. After assuming you win the case, assuming you win the right to participate for the condition you're pursuing, you may recoup some of the expenses that you spend. You may recoup all of them, but you may only recoup some of them. You may recoup none of them. The court will evaluate whether or not to reimburse those costs and expenses under a 3-part analysis, which consists of the following. They're going to look at whether those expenses are expenses traditionally charged to a client rather than overhead. So is this, like, for example, the videographer, the IME fee, those things, traditionally those would not be things that are part of overhead. Those are things you would charge the client. Whether they're reasonably necessary for effective presentation of cases. Number 2, obviously you need a medical expert, so you need either the IME or you need the videographers and transcriptionists for your expert's deposition. So you'd be fine in number 2, and then whether the amount is reasonable, and assuming your expert is not charging insane prices, they should be found reasonable. And I have come across instances, not on my side, but on the defense side, where the defense medical expert saw the bill for like their IME and file review, and it was $20,000. And I don't know if the attorney general ended up paying that full bill back, to that guy, paid the full $20,000. I have no idea how that works. That's insane. But the court in that instance, if you're trying to get your $20K back after you successfully won your 512 appeal, they might be like, $20,000 is a lot of money. That's kind of not, we're not going to reimburse that. But your attorney would have to explain why that's a reasonable cost. Maybe it's one of these really specialized medical experts, or some kind of specialized expert, and that's how much they charge in that area. That may be the case. So, with any of these 512 cases, your attorney, they may cover these expenses, and they may recover them, recoup them either, at the end of the trial from, the successful case. They may require you to pay for some of these up front. So, because all these doctors and things, they're going to require upfront payment. So your attorney might likewise say, we are going to represent you pursuant to the contingency fee agreement. Nothing with that will change. All the hours that we spend preparing for your case, preparing for these depositions, preparing the opening and the closing, etc., that doesn't change. Whether they spend an hour preparing for your case or 100 hours, there's still a contingency fee basis. And in fact, with a workers' comp trial, what ends up happening is your workers' comp attorney, they'll request statutory attorney fees, and the max that they could get for a successful workers' comp trial is $5K. So that's what they're going to get. So they're not going to come back to you and say, hey, you owe me, $200 an hour and I've worked 100 hours. It's contingency fee, assuming that's the kind of fee arrangement you signed up with. So that doesn't change. But they may require you to pay for these expenses, because these expenses aren't free. They cost money, and they may require you to deposit money into a trust account, and that money will be used exclusively and specifically just for litigation expenses, and then after, if none of the money or some of the money is spent and they don't recover it, then you get the difference, and etc. So, or if none of the money was spent, then they would give you back your money. So why might an attorney require a client to pay litigation expenses? Some law firms require their plaintiffs to pay the filing fee, just as a matter of course, and jury deposits and these things. But some of the other reasons why you might have a client, or why you might be asked to pay for expenses, is if the facts of your case are such that, unfortunately, it's unlikely. Looking at everything in reality with an objective eye, looking at with being real about it, it may be a type of case that the probability of success is so it's so low that there's you're likely going to lose. So in that case, the attorney might say, we will go to trial, we will spend all the time prepping for trial and all these things, but you're going to take on the risk of not getting paid back these costs and expenses if you insist on going forward with this trial. And that might be one of those instances where if the client is like, I want to go take it to the mat, whatever, and you can be like, cool, take it to the mat, but you're going to have to invest in your own case. And you're going to have to put, this is your case, you're going to have to put some of your own money into it. And as you should, it's your case. If you feel strongly about it, you should invest in your case. So that might be one basis. The probability of success is really low, and it's the high likelihood that you're going to lose. The other situation might be that there's still a reasonable chance of success, but in order to prevail, the expenses to get to the point where you prevail far outweigh the benefit of winning. So an example of this might be you suffered an injury, your claim's completely denied, but it's like a really weird, specific type of unique type of injury. For example, let's say you're working in an office and you have a vent and it has some kind of dust or smoke on the vent, and you're claiming that you've got some kind of lung issue as a result of that. You subsequently quit that job, or you got another job, or you moved, and those lung issues cleared up, and you only missed a couple weeks of work or a week of work, and you only had a couple bills associated with that treatment related to that lung issue. In that case, prevailing at trial all you're going to recover is, if you do get the right to participate, is you might be able to recoup the couple medical bills, which maybe not that much, and then maybe a C92 award. But in order to prevail, you'll need a pulmonary expert. Pulmonary experts are one of those type of experts that are not cheap. They might need to do an environmental study. So you might end up spending like tens of thousands of dollars to ultimately recover, maybe $1,000, maybe less than $1,000 in compensation and medical benefits. So in that case, it really wouldn't make sense to, again, pay $20,000 to get $1,000. So, but if the client is dead set on going to trial, and maybe it's the principal of the thing, and they have their principal is worth spending $20,000, your attorney might say, cool, we'll do that. You got to deposit this money because this isn't cheap. And then you might be like, oh, this is going to cost money. Maybe I'm not going to do that. So, but nevertheless, I think it's important to understand, because sometimes we'll get, the other thing is we'll get cases where the folks are, it might, the reason you may prevail, but the reason why you're pursuing it is less about getting medical benefits and treatment and more about getting some kind of revenge against your employer. You never want to be pursuing workers' comp cases and claims, either at administrative and particularly at the trial level, to get one over on your employer. That's not a good reason to get back to your employer through a workers' comp trial. It's just, you're better off spending your time and energy moving on, or whatever. But you want to go pursue your workers' comp case at court in order to get the condition allowed. So if you need to get treatment that you can't get any other way, that you'll be able to get the possibility of getting that treatment through your workers' comp case. So this is kind of an overview about the cases and expenses associated with filing 4123-512 cases in the court. Those would be workers' comp cases. And I just want you to understand that these cases, pursuing your case to court is not free. There are expenses associated with it. Your attorney may cover those expenses. Your attorney may ask you to cover some of those expenses. They may require you to pay some of those expenses up front. You've been listening to Attorney Kip from Malik & Malik. As I always say at the end of every one of these videos, workers' comp is, in Ohio particularly, is a confusing and labyrinthine thing. So if you have a workers' comp case, it pays dividends to contact an attorney or multiple attorneys to get an idea of how you should proceed with your case and your claim. I would not recommend you do this stuff on your own. And if you want to talk to us, you could talk to us. You could call me. You could leave a comment in the comment section. You could email me, and then we could talk about your case. If it seems like maybe you should get an attorney, we could discuss how that might work out. But nevertheless, I strongly recommend everybody don't do this stuff alone. Get a workers' comp attorney involved with your case. Hopefully you found this video informative. Please stay safe. Thank you. Bye. Attorney Kip.